Authorities Inquiries Procedure Scotland Rules 1998, and is a procedural meeting in relation to the making of the order by the Council and the objection to that by BT. I'll maybe just start asking people to introduce themselves for the record initially, and then I'll make a few preliminary comments before moving on to the agenda circulated previously. So I'll first of all invite agents for the Council, Fraser Mitchell, to introduce him and those attending both in person with him and one other person online on behalf of the promoters.
Morning, sir. Yes, I'm Fraser Mitchell. I'm a partner in the planning team at Shepherd Wedderburn. I'm instructed by the City of Edinburgh Council. In the room with me, I have Ashley McCann, who is a senior associate in the planning team at Shepherd Wedderburn. I also have Morgan Coulter, who is principal solicitor for the planning and property team at the council, and also Cara McGuinness, who is a trainee solicitor within the planning and property team at the council.
Okay, I think it's Ursula Curry next.
Good morning. My name is Ursula Curry. I'm a director at DWF and representing BT in respect of their objection to this CPO.
Okay, that's fine. And Henry? Oh, you're still on mute there.
Oh boy, error. Sorry, sir.
No.
Henry Church, Senior Director in the Compulsory Purchase Team at CBRE, providing compulsory purchase and valuation advice to BT in this matter. The various entities of BT that are involved here.
Okay, well, that's all fine. Whether that's an issue that might need to be clarified at some point, we'll maybe come to that, as opposed to BT as the principal objectors. Okay, thank you, and welcome to this morning's meeting. We have this set down for an hour, but we can play by ear as to the extent to which we need even that time or more, whatever if needs be. I was just going to make a couple of preliminary observation before we get into the substance of the meeting. First of all, is as usual, just to indicate for the record the participation in this meeting, which is being recorded and broadcast live, is consent for data protection and GDPR purposes for all those who are participating. As I say, the meeting is being recorded and will be available to be accessed by parties at a later date. For that reason, I wasn't planning on doing a minute of the meeting. As such, obviously, you can refer back to this on the DPA website if you need to. But if there are action points or other major issues arising from that, it's likely that I'll just ask my case officer, Claire Seidel, to issue a note to parties just to write down the kind of the key action points from that. But I wasn't planning on producing a formal minute as such. As parties will know, but just for the record, a number of documents have been lodged in relation to the order, and these are available on the DPA website, dpa.scotland.gov.uk, and anybody wanting to look at those documents or indeed future documents that are lodged, they can do so by searching under reference CPO-230-004. The procedure that we're considering today and after today is, as I say, proceeding under the 1998 rules, and follows in particular from a relevant notice letter issued on my behalf on the 14th of August. I circulated a suggested agenda for today's meeting on the 1st of October, which basically was the same as that indicated in the statement of key issues in the relevant notice letter, with various updates in response to correspondence between parties and otherwise since then. So the agenda, as I say, is as proposed. I'll maybe invite agents to say at this stage, is there anything that's unclear or anything else that parties wish to raise in relation to what we're dealing with this morning? Any other items for the agenda they might want to address before we get into discussion, or any other preliminary points anybody wants to make, and starting with Mr. Mitchell?
I don't think there's anything for us at this stage, sir.
Okay. And Ursula?
Likewise, I don't think there are any additional matters for us to raise, sir.
That's all fine. Good. Okay. The agenda, as I say, was issued last week. The first of which is just to give an update if there is anything to say, and there may not be very much to say. I've one question about the grounds objection principle, but I'll maybe just invite parties again, starting with the council, for an update on the outstanding grounds objection and the discussions between parties as they stand just now.
Thanks, Sarah. So dealing with them both in turn, so I think the outstanding grounds of objection, for Ms. Curry to confirm, our understanding is that the objector is maintaining the grounds of objection that were in their letter of objection.
Yeah.
One point that it would be helpful to clarify just now is that in her email, which I think was sent in response or just prior to the relevant notice, Ms. Curry had referred to dealing with topics, and I know this was in the context of dealing with the format the appeal or the inquiry would take, but referred to complex topics such as the safety of the gas governor. Now, that as a topic hasn't been included in BT's objections to date. Now, where I think it will become relevant to focus on that is in the next stage in terms of statements of case. And it may be that I'm better pausing and we deal with it there. And the reason I mention it is that we had confirmed to the inquiring authority that we would not wish to make a statement of case. But I think if there are just any changes to the grounds of objection from BT, we may look to alter our position on that. But nonetheless, my understanding is that the grounds of objection, such as we're aware of them, are being maintained. Discussions between the parties have continued. I think it's fair to say that they have been less intense than may have been helpful. But there has been discussions. We're at a point where I think both parties are seeking to try and resolve, if it can be resolved, issues around the CPO. My understanding is that if it's possible, may come down to technical matters, which but that's something which has been focused on by the council, the objective.
Okay, thank you. I too have some questions in relation to issues relating to that, and I'd noted too the degree of discussion in the past and some of the explanations linked to do with BT staff turnover and various things that might have at least in part have explained why progress maybe hadn't been as extensive as perhaps initially envisaged. But I'll go to BT just now on this issue, and I think we can maybe explore some of these issues later in the agenda.
Yes, the primary concern is really the impact on BT's operations, and the initial objection was very brief, but I suppose it falls under what I think was the third ground of objection in terms of the impact on BT as a statutory undertaker. I think there's been some discussion on the definition of a statutory undertaker, but effectively it's their operations under statute and what they require to do at the telephone exchange. There's a number of cables under the ground, and it's not clear what the impact of the gas governor is going to be on those cables, and even where they are physically in terms of each other. So I think we need some more information in terms of an engineering drawing which has been requested to see the impact on the cables and also the exclusion zones which will apply to the gas governor. And then the other matter which I had raised was safety, just considering the safety of the employees working at the telephone exchange with the gas governor in the vicinity.
Okay. Just specifically then on that question, just trying to think ahead to a possible hearing or inquiry of some nature, on the question of exclusion zones, is that something, insofar as you can anticipate now thinking ahead as to the inquiry, is that something you might anticipate would be addressed at a hearing of some nature? I'm just thinking about what are the sorts of rulings or recommendations that I could make to ministers on an issue relating to an exclusion zone. Obviously, CPOs can't be conditional, and so there's aspects of that. So it's very helpful to know a little bit of sort of the fuller kind of colour of the nature of the matters not yet agreed. But is there anything you can say just now about the extent to which that sort of technical advice is something that you would be leading before me in due course, and in which you'd expect me to make recommendations, given that I do have a power to make recommendations on modification as well as confirmation or refusal to confirm?
Yeah, I think that would be useful to discuss in some sort of hearing procedure or inquiry procedure potentially if it needs further scrutiny.
Yeah.
I'm not sure at this stage whether that would be for BT to lead on, because obviously it's the acquiring authority that will be putting in place the gas governor will presumably have the information regarding the exclusion zones and the safety relating to that.
Yeah, I mean, I think my question at this stage is thinking almost one stage beyond that of what parties, and I'm thinking mainly to BT, but it will be the council as well, what they might be expecting me to be doing by way of recommendations with that evidence. So I don't think, I mean, unless Mr. Mitchell wants to say anything further on that point just now, I think it's just a matter of parking just now. I'm not trying to preempt what a hearing might ultimately cover, but if parties could give some thought in relation to evidence of things like exclusion zones, you know, what that's going to lead to in general terms, in terms of what they might be looking for me to recommend. So I don't need answers to that just now, just flagging up what you would look me to be, or the sorts of things you'd look to me to be writing in relation to matters of that nature, given that my remit is in relation to the matters relevant to compulsory purchase. I don't know, Mr. Mitchell, do you have anything on that point, or is that clear enough at this stage?
I think it's clear enough, and I think it would be one for for us to consider, as it would be for BT to consider in terms of what would be required. What I guess I would say at this stage, more on the procedural side of things, is that this maybe goes to the heart of which party leads on this.
Yeah. Is
that we have council have set out a position within their statement of reasons in terms of exclusion area, and it would be helpful to know, and again, come on to this, I suspect, under the statement of case discussion, it would actually be helpful to know what BT's grounds of objection are and the particular points that they disagree on. And then that would give us, as acquiring authority, an opportunity to respond on that.
Okay.
That might, as I say, that may be for a statement of case discussion.
Yes, I'll come on to that just a moment, but Henry's got his hand up just now. Henry, can bring you in?
Yeah, thank you, sir. I think it's fairly straightforward in that Edinburgh City Council want to do something this location, the concept of which is fine. I don't have the challenge is that BT does have a statutory, what we consider to be a statutory undertaking, and it seems to me that it's for the acquiring authority just to give us comfort that what they're proposing to do does not impact that statutory undertaking, be that employees within the telephone exchange or in relation to any risks that may arise from cables running in close proximity to the gas governor itself. So it works both ways, and we need comfort. Simply, we need comfort over that, and those discussions are taking place. But I think I agree with Mr. Mitchell in that when he says that they perhaps have not been as intense as they might be, and it may be that the impending inquiry focuses mine, sir.
No, indeed. I'm always very reluctant to use the phrase "we are where we are," but it's I think the reality is that we are where we are. Okay, now I'll come on to that. I'm just going to divert off to a little bit an issue just for my reassurance on a slightly different point. Then we'll come to agenda item 2, which is statements of case, which actually will pick up on some of these things. And the thing I just wanted to be clear about, as I understand the position and reading the council statement of reasons, is that for all the various objections that BT have, there doesn't seem to be a suggestion as such that Edinburgh City Council should be looking at an alternative site. I'm thinking of Rule 6 of the 1998 rules, where it's possible it could be argued that even if it's accepted that the need on the sports stadium side is made the kind of the why this site question. Now that's addressed at section 7 of the council's statement of reasons. There's been no suggestion in the objector's letter in relation to the the objection here that they're wishing to pursue any Rule 6 type circumstance. I mean, I suspect it's probably quite late to be raising that, but just to be clear from my own point of view, I take it there's no need. I'm proceeding on the basis there's no need for me to be examining any issues under Rule 6. I'll go to the objectors first.
I don't think that BT have considered alternative sites in any details, but the only consideration is whether it can be accommodated within the wider housing site.
Yeah. I mean, the Rule 6, I mean, it's one of the obscure rules that the parties may not be all fully familiar with, but it is a situation where an objection might be made where a person's proposing an alternative site, an objector proposing an alternative site. It's open for me to examine that possibility, but there's no hint of that in the BT letter of objection. And I just like, for my own peace of mind, to be satisfied that in fact that there's no issue being taken. In that respect, I think you've confirmed that, and as I said already, I think Section 7 of the Council's statement deals with alternatives, maybe not quite in the Rule 6 sense, but deals with the question as to how they alighted upon this as a proposal. Mr. Mitchell, is there anything you wanted to say about that? Or, again, does that cover that?
I think that covers that. So just and so we'll be aware as well. Just I think it's Appendix G of the statement of reasons sets out the alternative sites and consider and discount.
All right. Okay. Yeah, that's helpful. Thank you for that. Okay, moving on then to item 2 and statements of case, and thank you to the council who confirmed at this stage they're happy to adopt their statement of reasons as being their statement of case. I think what I'd said in my relevant notice letter is that I've been envisaging that within 4 weeks of this meeting, the objectors will be called upon to lodge their own statement of case. So there's a wee question there for the objectors as to whether 4 weeks is the right period. But there were a couple of aspects that emerged from that I certainly would find it useful if the objectors, when formalising their relatively short letter of objection into a formal statement of case, were to include some further information on to help inform my consideration of this. And one of them is the point that Mr. Mitchell referred to already. I'd like to understand a little bit more, just a little bit of unpacking as to what the objectors actually mean when they're talking about fettering of discretion. And I too was thinking as to whether the question of unpacking the examination of exclusion zones and protection of the BT position is really covered by that. I think it probably is, but at a general level. But having said that, it would actually be immensely helpful for me to understand a little bit more in the statement of case as to what's really meant by that. What really does the fettering of discretion actually mean? And without including sort of evidential things in the statement, just to say a little bit more about how that impacts with what Henry's been talking about just now, but also what BT generally have been talking about. So it would be very useful. Specifically, the other 2 grounds I can get my head around, but and appreciate the letter of objection was probably intended to be fairly brief. A bit more detail as to what all of that means. And it actually related to that, I think, is this dispute between parties as to whether BT are technically a statutory undertaker or not. And I think I'd like in their statement of case to get a bit of a better understanding, if you like, why that matters. Obviously, one of the things that I would expect to be taken into account is the BT equipment is important to maintain the continuity. Telecommunications are extremely important, and that whether they're a statutory undertaker or not, it'll be a matter of interest to me, a matter I want to hear about. If there remain any real concerns about the continuity of service or the future provision of service, whether or not you're a statutory undertaker. So I may or may not have to make a recommendation on that point, but even if the BT are not statutory undertaker for these purposes, obviously they carry a very important role. So it would be helpful if I could steer the objectors to when they submit their statement of case to address in I was going to say a bit more detail, but as much detail as you can about those particular issues which are a little bit scanty from the letter of objection, so that both the council and myself can understand kind of the real root of the objection with that in mind. So hopefully that's helpful. Again, but I start with the objections. My first question is 4 weeks enough? I'm conscious that for some people are going into maybe a bit of a holiday period with schools off next week and things. But my first question is whether 4 weeks is enough, and second is whether that steer is clear enough as to what at least I would find helpful.
Yes, thank you, sir, for the guidance on what you're looking for in the statement of case, and that's all understood, and we'll look to address those points. I think 4 weeks should be sufficient. The only thing which might take a little bit longer is we're looking to obtain some information about the location of the cables, and I'm not sure if that might take a little bit longer, but that perhaps is more in terms of the documents rather than the statement of case.
Okay, that's all fine. And I would have perhaps in mind, and again, subject to what the council may say, I have in my mind the idea of having a time period, perhaps 3 weeks after that, for the council to respond to anything in the statement of case. But I'll maybe ask Mr. Mitchell for his comments on this issue generally, both on what I've been discussing about the objector statement, but also a 3 week period for the council to respond from receipt of the statement.
Yeah, so sir, I think you read my mind in terms of the if you like, the staggered approach to statements of case, because I think that would be very helpful. And just on a practical basis, so there's an opportunity there for the objector to set out their concerns in full, and for the council to respond to those concerns. And part of the reason I say that is that the specific concerns, as I understand them, were not, I'll use your language, maybe a little bit scanty in terms of the letter of objection. So it would be helpful to see them in full. So the council would be very much in favour of the statement of case coming in 3 weeks would be a sufficient time period for the council to do that. In terms of the broader point, beyond what you said, I'm not sure I have any comments on the points that you've raised, and Ms. Curry's come back on that. It seems sensible to me that those are addressed just in a more fulsome manner.
Okay, that's helpful. Thank you. And moving on to the next issues, which is probably the 3 and 4 on the agenda, probably sort of roll into each other to a certain extent. I should say, just as a sort of starting point in terms of my own commitments, and I'm obviously subject to representations to the contrary from parties, is that for an oral examination, because of other commitments I've got, and indeed thinking of those timescales I've just been speaking about, I'm certainly not thinking about an oral examination before the end of this year. I think the earliest I think will be feasible will be sometime, hopefully as early as possible, into 2026, but certainly into the new year, unless that creates a particular difficulty for parties. In terms of the form of the examination, I think it's been suggested by the objectors. I think it was the objectors who preferred an in-person rather than a virtual hearing, and I have no particular difficulty with that. My one proviso, because all public bodies or publicly funded bodies are conscious of the kind of cost implications of doing things. If there was going to be an in-person examination in one form or other, I'm reluctant to commit DPA to the expenditure of booking hotel rooms or conference centres or whatever. I was going to suggest, if this is possible from the council, and if the objectors have no objection, whether it might be possible for a room in the city chambers or somewhere else, some of the council facilities, to be made available in the event that we proceed with an in-person hearing for whatever length. I know that's not the norm, because we normally like to have these inquiries at neutral venues. I'm conscious of the nature of BT. They're not a body that I think they're a grown-up body. They don't really need to worry unduly about these things. So I'm going to ask the council first of all. I know nobody will know the answer to this today, but whether one of the council officials would be able to explore the availability of a suitable or appropriate location. You can guess the size of number of people will be involved to host that within the city chambers or elsewhere, and then I'll go to the objectors. Council first of all.
Yeah, so from the council's perspective, that would be fine. Between the city chambers and Waverley Court, We are fairly confident space can be found that would be suitable.
Yeah. Okay, well that's fine. Maybe it's one of the sort of actions from this, if that's ultimately agreed. Some preliminary investigation can be made just to sort of start looking at kind of dates. I doubt we'll be fixing a date for the hearing today, but if that could be begun to be explored, then that would help us when it comes to fixing the date in due course. But from the objectors' point of view.
Sorry, I didn't mean to speak over you there, sir. I was just going to say that just on a matter of practicality, if it may help the objector. In terms of finding space, I think it would be envisaged as both being the space in which the oral hearing can take place and also accommodating individual space for each, if you like, each party, each team. So, and indeed use also to have a breakout area.
Yeah, that might be. Yeah, thank you. So, BT.
Yes, I don't see any difficulty with it taking place within the City Chambers or Waverley Court.
Okay, thank you. And the related question then is the sort of the format of a hearing, or I think the objectors have talked in terms of potentially the need for a hybrid procedure because of the possible technical nature of some of the evidence. And I can kind of get that point. Again, I have no particular objection, and it may not be possible to make a kind of judgment just now fully as to the nature of the hearing. I can see that if indeed it does transpire there is some highly technical nature, whoever leads on this, and that's something I'll give some further thought to, that a hybrid procedure is necessary. It actually struck me, in fact, rather than a hybrid procedure, it may well be that in terms of kind of substantive evidence, and I'm keen not genuinely trying not to kind of get too far ahead of myself here. I do kind of wonder whether the other objections are ones that are more suitable for legal representations in writing and indeed orally at a hearing, and the extent to which a sort of a hearing session led by me may not actually be that necessary. As I say, there'll be parties might make legal representations on the first two grounds of objection, and the third one might be a kind of almost standard PLI on the points that BT are making. So there may actually need to be no hearing element of this. But that again maybe is just a thought in advance. But I'll maybe start with BT on that as a thought.
Yes, sir, I agree that I think the fundamental point is going to be the impact on BT's operations and how that interplays with any technical evidence. So I suspect the first two grounds of objection could be dealt with by way of legal submissions.
Okay, pencil.
So yes, I certainly agree the first two grounds of objection can be dealt with by way of written submissions. It strikes me that I'm not wishing to put words in anyone's mouth, but it strikes me that the third ground of objection is there's quite technical, there will be technical evidence in connection with that, but I suspect if that's presented in a written form, we may find that we are not particularly far apart, if at all, on that. So the dispute, if there is any, might just centre on, if you like, impact, which would be potentially slightly more subjective, but I think the fundamentals, even on ground 3, again, such as I understand it's going to be just now, I think a large portion of that could be dealt with by way of written submissions.
Okay. I'm very happy to leave this just in the air just now until the statements of case are submitted and responded to and further discussions take place, and then we can take that forward. But I just wanted to sound out those general points in principle, and I suspect that is also the answer on the question of how long do you think a hearing might take. I think it's probably too difficult to say just now, so I'll maybe just let that walk out. And come to any thoughts. If anybody has anything want to say about potential length of the amount of time we need to set aside, which might be important for the council if it's looking for rooms. It may not be easy to get rooms if it's more than one day. But I don't know if either party have any views at this stage they want to say about potential length, or is that just too hard to speculate at this stage?
So I'm happy to give a view that I mean we'll have to wait and see what comes out of the statements of the case, but the way things are shaping up, if it's focused on either being likely a part of ground 3, then I suspect we could deal with it one day.
Objector's view.
Yes, I suppose it is a little bit early to say without the statements of case being fully fleshed out, but perhaps a day or two might be sufficient to deal with these issues.
My gut feeling was possibly a day, but it is very much conditional on those other matters. So that's very helpful. Thank you. I wasn't going to say very much under item 5 of dates of submissions of documents because of the continued kind of uncertainty as to the dates. We know it's not going to be into the new year. The normal expectation would be, and it may arise if there are technical documents that need to be submitted, of looking for a submission date of 1 month ahead of the start of the oral procedure that arises. And it's possible that some of the documents might be of such a technical nature, again, depending on the statement of case, that it might end up being wise to have these before me and before each other, so I can start getting my head around them. More than that, but my starting point would be to probably aim at 4 weeks ahead. More importantly, from my point of view on this item, is the issues of witness recognitions. And again, mindful of what's being said to me before today and today, I'm probably going to be asking for recognitions, whatever the procedure is going to be. I tend to be slightly unusual in that I do sometimes ask for recognitions, even if it's a hearing. So it would actually probably be useful if parties could be aware that if we are going to be focusing on some of these technical things, then whatever the form of hearing, the maximum information that can be contained in documents and the maximum information that can be contained in witness recognitions will certainly make things easier in the day. But again, I'll just invite parties. Again, we were starting with the objectors first of all, for any comments on those aspects. This is, as I say, agenda item 5.
Yes, there are no difficulty with documents being submitted 1 month prior to the oral procedure. And sorry, did I miss a suggested deadline for the precognitions? Was that?
No, I didn't say. I didn't give a deadline for the recognitions, but I should have done. I would imagine that would be the same.
Okay.
But the key point really is to put you on notice for your respective witnesses. Once the position is clearer, that I think I would prefer to have recognitions from parties, whatever the procedure that we adopt. And I say that just because that's a slightly unusual way to proceed. Not all reporters will proceed in that way. But Mr. Mitchell.
So yeah, I agree. I think that well, certainly no difficulty with documents going in 4 weeks before the procedure is agreed upon or is set out. And as for recognitions, yeah, no difficulty with those going in either. In fact, would be quite helpful. I would hope by that stage we might just pick 1 witness each, but I think recognition would help to shape the procedure around.
Okay, thank you. Item 6 are 2 more technical things. Just again, possibly just for my understanding in terms of my consideration of matters in preparation for a hearing. And the first of those is related to planning matters. Sometimes, as you'll all know, sometimes a compulsory purchase order will come forward where planning permission has not been granted, and there's sometimes circumstances where planning permission has been granted. Although Scottish ministers are the ultimate planning authority, I'm mindful in these particular circumstances that planning has been granted already for the housing, and indeed I think is 18 months into the period towards the starting implementation date, but also for the gas governor side. And so it would be kind of useful to know whether parties anticipate the leading of evidence relating to planning matters that otherwise look as if they are kind of reasonably clear. And I make that point simply because it's not within my remit to revisit decisions made by the local planning authority. There's no role of Scottish ministers absent any other appeal or other process. I take it just for clarity, Mr. Mitchell. I take it that neither grant of planning consent has been subject to any kind of review or challenge.
No, both of them are still valid.
Thank you. So from the objector's point of view, are you in a position to say just now, don't worry too much if you're not, whether you're expecting a hearing to be delving into to planning matters.
I wasn't anticipating that going. Yeah, I wasn't anticipating that in any great detail. I mean, if planning's already been granted, we wouldn't be looking to revisit those matters.
No. Yeah, as I say, sometimes when planning permission is not being granted, the planning circular requires me not to express a view on planning matters, because that's the local planning authority and strictly within their remit and their jurisdiction. But I do sometimes examine the likelihood the planning permission is to be granted. But we're just not in that position just now with 2 consents in place. So I'm not anticipating that being an issue. And the second matter, which is just kind of sort of maybe something becomes superseded as to whether there's anything that's intended to be brought in terms of witnesses from Scottish Gas. I'm conscious SGN are not represented at this meeting, and the only reason I raised it was just to ensure that if there is any likelihood that witnesses or other information or evidence coming from SGN is liable to be produced at the hearing, just to make sure that someone's in touch with SGN and are making their own arrangements, because I'm not making arrangements, obviously, to ensure that SGN are fully engaged in this part of the process. And I guess that's probably an objector's point there to comment on first.
I don't believe there's been any contact with SGN so far. Maybe Mr. Church can correct me otherwise.
Yeah.
No.
I'm not suggesting it should have been. I'm just saying that because they're a third party, and sometimes that creates its own complications around the obtaining of evidence from parties who have a less direct interest in this. Okay. So, Mr. Mitchell, anything you want to say on either aspect of item 6?
Well, only in planning matters, just to repeat, I think what's already been said, and I think Ms. Clary's confirmed that there's not likely to be any point taken on the planning merits or otherwise of the proposal. So just to say from the council's perspective, we're not expected to see any, just given the planning circumstances that prevail. On the second point, in terms of Scotia Gas Networks, the council is understandably in touch with SGN in terms of the works they have. They have tendered those works to the extent of getting a price for carrying them out. And Scotia Gas Networks had input in terms of the technical matters and the safety considerations that went into the statement of reasons. So it may be that further evidence is produced from SGN that may come under the ambit of the acquiring authority, but it would depend upon what comes out in the statements of case and what matters have to be addressed.
Okay. Well, thank you. That's very, very helpful. My last item on the agenda was a site visit. I think I've indicated to parties that I took a look at the site 2-3 weeks ago and went onto the land, whether I was meant to or not. I had a look onto the site. The gate wasn't closed, so nobody stopped me for that. So I've seen the site. It may well be that parties around the date of the hearing feel that an accompanied site visit is going to be beneficial. I don't know if anybody has any particular views at this stage. It's something we can obviously deal with around the date of the hearing. Again, starting maybe from the objectors first of all.
I don't know, Mr. Church, if you think that it might be useful for an accompanied site visit.
The risk of putting it back on you, sir. Our case will be our case, and if you think that there is benefit, I'm not sure that I see a huge benefit in it, because I mean the case around safety stands on the information, not necessarily what we're going to see on site.
Okay, and Mr. Mitchell.
So we would have no objections in the accompanied site visit. That's maybe not quite the same as proposing one. But I think that depending on what comes out in the statements of case, it may be that accompanied site visit could be useful. Just in the sense that there are very specific features in the site that might be useful to draw to your attention, and that may be for one of those parties.
Okay, that's very useful. Again, we can park that issue. That's not just now. And that was my list of questions. I don't know, and I'm going to start with Mr. Mitchell in this case, whether there's anything else you think we should be addressing at today's meeting that's not covered by the agenda or otherwise you want to raise.
So nothing from the acquiring authority. That's not very helpful. Thanks.
Okay, and the objectors?
No, sorry, nothing additional.
Okay, well, thank you. I've managed to conclude that in 40 minutes and give you 20 minutes of your day back, which is all helpful, hopefully, for everybody. So thank you for your clear responses and helpful contributions today. As I'll maybe ask my case officers to a brief email out to you, just noting the various things that we have touched on today. And if there's anything inaccurate that I miss about that, please feel free to shout. But otherwise, I'll thank you again and just bring the meeting to a close. Thank you
Very much.
Thank you.